Right, I'll just admit everybody now, Sophie. Okay, people are now joining. Sophie, I'll keep an eye on the waiting room and the chat box.
Fantastic, thank you. Good evening, everybody. We're just getting everybody in from the waiting room and then we'll get started very, very shortly.
Yeah, I'll just turn off that sound as well that plays when somebody joins. I don't know if they hear it, but we certainly do. So anyway, I've turned it off now.
Okay, right, welcome everybody. I think we have everyone in from the waiting room, so thank you. So my name is Sophie Gupta. I'm one of the tutors here on the Barbary course, and I'm going to be doing this workshop alongside Helen Munro. I think you've probably come across both of us before in previous workshops. Anyway, I'm going to be looking at a business research exercise that you had in your PSP, I think in week 13, and Helen is going to be dealing with a property drafting exercise that I think was possibly the week following that, so last week.
Week 14, that's right.
Great. Okay, so we're going to run it in the usual way, and by which I mean I'll deal with the research exercise, probably spending around 20 minutes talking about that, hopefully. If you have questions, there'll be plenty of time for questions, but if you could just pop them in the chat whilst I'm kind of presenting, and then I will pick up the questions at the end of my bit, and then we will switch, and Helen will talk to you about the property drafting exercise, and then she will take questions at the end of her section. Okay, so if questions occur to you as we're going along, pop them in the chat. Otherwise, if you want to just come off mic, that's fine. But if you could just wait until we kind of invite questions, that would be great, so that we can make sure everything runs smoothly. Okay, right. So I'm going to start by sharing my screen. So just bear with me a second. Okay, right. So my plan for this session, when I'm dealing with the research exercise, is to use this session to demonstrate how I would go about answering the question. I'm going to skip over recapping on research generally and the assessment criteria and get straight into how to approach the exercise, because I think I'm going to be fairly tight for time anyway, and what I want to focus on is a practical demonstration. So I want to demonstrate, firstly, how I would get to the answer using the sources that are provided, and then secondly, how I would write the report using the new SRA approach. So I'm sure you'll be aware that the SRA issued a new template or a new exemplar for their sample question, suggesting a new approach to writing your report for research. So I'm going to follow that and use that approach. In order to do that, I'm going to be attempting to put together the report on screen, which may or may not work. So feedback is very welcome. Don't worry though about trying to write down what I'm doing or taking screenshots of the screen or anything like that. I'm going to make sure that all of the wording that I build up on screen goes into the slides, and then they will end up on the PSP. Okay, so you'll be able to get that wording from the slides later. So you don't need to be desperately trying to copy everything down, just focus on following along as I do it. Okay, I know Helen did a workshop a couple of weeks ago, didn't you, Helen, on research? So I think and that you went into the new format of the SRA answer in quite a bit of detail, going through the structure of it. There's also guidance on the PSP analysing the SRA sample answer for research. So I am assuming that you have seen both. I'm going to work from a position that you know what the SRA sample answer is. Okay. So I'm just going to skip over the assessment criteria. You'll be well aware of those by now, but let's just look at the approach. So this is the approach that I would suggest you take when you're dealing with a research exercise. So the first thing I would do is just make sure I spend a little bit of time understanding the question, making sure that I really understand what am I being asked to do, okay? And then noting the issues as headings in the answer template. The next thing I would do is set out a brief introduction. Now, the SRA sample answer has a sort of summary of the kind of key facts of the problem at the beginning of it. And I think that actually does work quite well, because it helps you get the issues straight in your mind, helps you really kind of clarify your thoughts as you're starting to process the question. And it helps you make sure that you are focusing on the issues that the client wants you to deal with. So they sort of set out a brief introduction with key facts in it, and then a sort of statement of, I've been asked to research X and Y. And I think, as I say, that works quite well. So I would do that as the sort of second step. Thirdly, I would look at the list of sources that I've been given and skim through that to see what's there. And then I would move on to look into the sources. So I would start, it usually works best to start with secondary sources, that's the textbooks, and then move on to the relevant primary sources, so statute or case law. You then need to set out your analysis for each issue, and then just to go into some detail. Now, the difference with the new SRA format is that you include your statutory references or your authorities within that analysis. So you don't have to separate them out into kind of a part one, part two approach like you would have had to do previously. And I think that's much better, actually, because I think it's much easier to do. And I think it's more realistic in terms of how you would actually write a report for a partner in real life. So hopefully you will find that as you get to grips with this new format, that actually it's actually a little bit easier to deal with. The other thing that the SRA sample answer does, which I think is quite nice, is there's a brief conclusion, a sort of summary of the findings, if you like, that they put into the introduction, so at the end of the introductory bit. So basically the structure is introduction and facts, what's the question, what have you been asked to research, followed by I have concluded that, whatever. And then I would then have subheadings for each issue and put my detailed analysis below. And I'm going to show you how I would set that out. And then obviously always you need to leave time to review and improve your answers. Okay. What I'm going to do then is look at the question. I'm going to pull that up on screen. Okay. And I've also got an answer template set out ready to use. Okay. So let's have a look at this question then. So we've got the kind of setup, first of all. We've been instructed by Stacey Goldberg, recently appointed company secretary of our client company, All Action Limited. The proposal, the company is planning to issue 25,000 new £1 ordinary shares to its finance director, Gavin Crawley. And then the problem, the company was incorporated in 1997. It has an old style memorandum of association predating the Companies Act 06, which sets its authorised share capital at £100,000. It already has an issued share capital of 100,000 £1 ordinary shares, so it has reached this limit. The company's articles of association haven't been altered since it was incorporated, and it has unamended Table A articles of association. And then you just got a little explanation of what Table A is. We then have the specific questions set out. So what the client would like us to answer. So Stacey would like to know whether the company can still issue the new shares to Gavin despite the limit in its memorandum, and if so, what it should do about the limit and whether there are any particular procedural requirements. And then secondly, whether Gavin can vote and count in quorum on board decisions relating to the allotment of shares to him. Okay. So the first thing I would do is, given that the question sets those two issues out neatly and clearly, I would pop them straight into the answer template as headings. Okay. And then I know what the issues that I need to deal with are. And they're two very distinct issues, they're two separate questions, essentially. So for today, in this presentation, I'm going to focus on issue 1, okay? And I'm going to walk you through how I would approach answering issue 1. Okay, I don't think I'll have time to deal with issue 2 as well, but hopefully once you've seen how I go about it, you'll then have a good idea about how you could go about dealing with issue 2. And obviously you've got the exemplar as well. Okay, so I think the next thing I would do at this stage is the brief summary of the instructions to help me get the issues straight in my mind, and to form the introduction to my report. So in other words, dealing with step 2 on that approach that I was showing you before. So I want to be saying that, so All Action Limited is planning to issue shares to its finance director, Gavin Crawley. It has an old style memorandum of association, and that sets its authorised share capital at £100,000. It already has an issued share capital of £100,000 ordinary shares, so it's reached this limit. Okay, so most of that we can just lift from the question. I'm also going to put the information about the articles in there, even though that sort of relates to the second issue. Okay, and then we want to set out what we've been asked to research. So that's really just reiterating what is in the question. Okay, I'm going to pop that in there. Okay, right. So that's my introduction done, and that's set out what it is that I need to do. So let's go back then to our approach. So the next thing we want to do is look at the list of sources. Okay, so we've got 9 sources for this exercise. And if we look at the list, we can see that sources 1 to 5 are all primary sources, and then 6 to 9 are secondary sources. In other words, textbooks or encyclopedia. As I said before, generally, not always, but generally, it's going to be best to start with the secondary sources, because what you're hoping is that the commentary that they have will give and explain the answer to the question to you, and you can then use that to form your answer. You'll then obviously need to verify anything with primary sources as necessary. So in terms of secondary sources, we have 2 extracts from Holsbury's and 2 from Palmer's. Okay, Holsbury's you'll be familiar with, I'm sure. Palmer's is just a more specialist company law text. So we're dealing with issue 1, and so we need to consider, don't we, what's the effect of that limit on authorised share capital that's was in the company's memorandum of association? What's the effect of that now? Can the company issue any more shares? And if so, are there any procedural issues that need to be dealt with in relation to that? So I'm going to start with Holsbury's. So I'll go to the first extract from Holsbury's, which is source 6. Now, one of these will be source 6. I've got them open up here. Okay, right. The next thing I would do is I would actually just skim through this source. I'm not going to read it from beginning to end, because it, you know, there's a lot there and it might not be relevant at all. Holsbury's happily has subheadings, which helps navigate. So I would just jump from one subheading to another, looking to see if they sound relevant. And we're talking about issue 1 here. Okay, so keep looking through. No. So everything I'm seeing in source 6 seems to relate to articles of association. Okay, so not relevant to issue 1. Might be relevant to issue 2, but not relevant for now. So let's go on to the second extract from Holsbury's and start scrolling through that. Okay, so first subheading, no, not really. Authorised minimum share capital. Public companies. We're not dealing with a public company here, so let's move on from that one. Nominal value of shares, no. Nope. Right, here, former requirement for authorised capital. This could be more promising. So let's read this more carefully, okay? So, if we read through it, it confirms what we know. So a company was required to state in the memorandum of association the amount of its authorised share capital divided into shares of fixed nominal value, this amount operating as a limit on the number of shares that could be issued, subject to the power of the company to increase this figure. So that was the position before. Yeah, know that. Companies Act 06 contains no such requirement. Yeah. Although a company may choose in its articles to limit the power of directors to allot additional shares. Okay. For existing companies, the position is subject to transitional provision. Right. that is what we need to look at, I think, because we have an existing company, a company that predates the '06 Act. So we need to know what the transitional provisions were for those companies that had a historic authorised share capital. So the reference is to two footnotes here, 5 and 6. So let's scroll down and look at those. Footnote 5 just confirms that this means companies formed under the predecessors to the '06 Act. So that's good. That's what we want. And then footnote 6, there's quite a lot in there, but it tells us about the transitional provisions. And it refers to a statutory instrument that contains the transitional provisions, and also to the Companies Act 2006 Part 3, Chapter 3. Okay, and what it says, sort of relevant part of this, tells us that the authorised share capital is treated on or after the 1st of October 09. Okay, so it's treated on or after the 1st of October 09 as a provision of the company's articles setting the maximum amount of shares that may be allotted by the company. Okay, so that authorised share capital still exists, it's just it sits now within the articles of the company. And it may be amended or revoked by the company by ordinary resolution. And that's interesting because it's the authorised share capital still exists, it sits within the articles of the company, but it can be amended or revoked by ordinary resolution. And I'm sure you'll know, normally to make any amendment to a company's articles, you need a special resolution, but this specifically sets out that this can be dealt with by ordinary resolution. So that's what our client is going to need to do. So the authorised share capital still remains valid and exists within the articles, but they're going to need to amend or revoke it by ordinary resolution. Okay, now, since we can't, it also goes on to tell us that these sections of the Companies Act apply to any such resolution. So there's something funny about that ordinary resolution that we need to check in the Companies Act. Okay. So I think what I would do at this stage, because I can't highlight and sort of save highlighting in my document in the exam interface, when you go and test it, you'll see that. I think what I would do is actually copy and paste that into my report, not because I'm going to leave it there, I'm not, but just so that I've kind of captured that text, because there's quite a lot of useful stuff in there. There's, you know, things like the full name of the statutory instrument, which is fairly lengthy. So it will save me some time later, I think. So I'm going to pop that in there. So that kind of gives me the answer, but what I need to do is verify what Holsbury says in the primary sources that I have. Okay, so I'm going to look at my list of primary sources, and both the transitional provisions, which are there, and Chapter 3 of the Companies Act have been provided to me. So that suggests I'm expected to look at those and look at those primary sources. Okay, so I'm going to do that. So I'm going to start with the transitional provisions in source 3. Is that source 3? Yes, okay, yeah, there we go. So transitional provisions, blah, blah, blah order. And if I scroll down, I can see the bit that I want is paragraph 42. Okay, so saving for provisions as to the amount of authorised share capital. And I'm rushing slightly here because I'm conscious of time, but if I read through this carefully, what I'd see is that the key references that I'm going to need are paragraph 42 2A, which tells us here that the authorised share capital is treated as a provision of the company's articles going forward, and 42 2B, which tells us that it may be amended or revoked by the company by ordinary resolution. Okay, so I would probably jot those two statutory references down in my on my whiteboard because I'm going to need them. And the other thing just to be aware of is that paragraph 42 3 cross refers to chapter 3 of the Companies Act telling us that that applies to any such resolution. So if the company passes an ordinary resolution relying on this, they need to also deal with Chapter 3 of the Companies Act. Okay, so we need to check what that says as well. Okay, so jot all of those down. Then I'm going to look at the Companies Act. And I had that in source 1. And if I go to that, I'll see that the key thing is that section 30 tells us that certain important resolutions, when they are passed, a copy of them has to be sent to the registrar, so Companies House, within 15 days after it has been passed. Now, why is that important to note? Well, because normally you wouldn't need to file a copy of an ordinary resolution at Companies House. You would if it was a special resolution, but you wouldn't normally for an ordinary. But section 30 tells us that for this ordinary resolution, we will need to. Okay, so again, I jot that down. Okay, hopefully you're all still with me. So the next thing I need to do is to write my answer, my detailed analysis in clear English, answering the client's question. So I can kind of paraphrase some of what I've copied over from Holsbury's, or cut and paste the odd bit into it. We need to incorporate references to authority for each point that we make, but we don't need to copy all of the statutory wording into the report. So because I'm very slow at typing, I'm just going to copy and paste what I would suggest in terms of wording to achieve this. Bear with me a second. Sorry, I've just managed to lose the template as well. Okay, so what we want to be saying is something along the lines of this. Okay, so companies incorporated prior to the Companies Act 06, I'm going to define that, coming into force in 2009, had a limit on the number of shares they could issue set out in their Memorandum of Association. Since the 1st of October 09, this has been treated as a provision of the company's Articles of Association. And then I'm going to give the authority for that. Okay, so I jotted that down earlier, para 42.2a of the commencement order, the transitional provisions. Okay. I'm then going to go on to say that Chapter 3 of the Companies Act applies to such an ordinary resolution. And I'm going to say why. So paragraph 42.3 of the commencement order, and cross-reference to the Companies Act. What's the effect of that? Well, Section 30 says that a copy of the ordinary resolution must be sent to the registrar within 15 days after the resolution was passed. Okay, then I can delete the wording that I'd copied in from Holsbury's, so I don't need it anymore because I've written it up myself into plain English. And then the final thing I'm going to do on this issue is just summarize it and put a quick summary into the end of the introduction up here. Okay, a bit like, oops. Okay, so I have concluded that the company can issue shares to Gavin, but its shareholders first need to pass an ordinary resolution. A copy of that ordinary resolution needs to be sent to the Registrar of Companies. And that's it. That's the answer to issue 1. Obviously, the more detailed analysis I've set out below, but in terms of a kind of executive summary, if you like, at the end of the introduction, so that the supervisor can look quickly, what are the pertinent facts? What were you asked to research? What's the headline conclusion? So I've popped that into my report here, and then the supervisor can go on to look at this if they want the more detailed analysis of how I've got to that conclusion. You could, of course, have got to that answer by using Palmer's. You didn't have to use Holsbury's, or you could have gone straight in with the legislation. There are lots of different ways to get there. I just wanted to demonstrate the way in which I would have done it, just to give you an example. You've obviously then got to rinse and repeat for issue number 2, which I'm not going to deal with now because I want to leave some time for questions. So I'll stop sharing my screen, and then Helen, if you have questions.
Yes, we have. Actually, I was just looking into one that I've not been able to answer, but I've
Okay.
answered them. So, and what I'll do is I'll read them out and I'll tell you what I've said, and then you can add
Okay.
to that if that's okay. I just thought we'd save time that
Yeah.
way. So, Alicia or Alicia, sorry if I'm pronouncing that wrong. At the start, should we be doing a summary sentence explaining I have been asked to research X and I've concluded Y because of Z? And she asks this because she says some of the research questions aren't a specific yes no type of answer to a question, and they don't quite fit that model. So, for example, researching about a lengthy process wouldn't quite fit that model. What's a different way of doing that summary? And I've said, yes, I think it depends on the scenario, but if you want to mirror the SRA approach as much as possible, and let's face it, who doesn't want to do that? You could say something like, I've been asked to research whatever it is, what the procedure is for whatever it is, and this is set out below. So
Yes,
rather than do
absolutely.
it gets a bit nearer to it. It's not
Yes.
exactly the same approach.
Yes.
Do you think
Yeah.
that's the right?
Absolutely, yeah. I think it's just a summary, however it feels appropriate. It's
Yeah.
just for clarity. It helps you organize in your mind what you need to do, and it shows the examiner, which is at the aim of the game at the end of the day, that you have understood what your instructions are and what's important in relation to them.
Thanks, Sophie. This one was a little a teaser, really, and I checked it, but I'm really interested, and I've got a couple of bits of feedback on it. So, can I check whether the find feature is barred when it comes to legal research, but not for the other computerized exams? I have to say, I've never come across that question before. I did double check it whilst you were speaking, and the find feature seems to work just as well
Yeah.
in legal research as the other ones. So
Yeah.
yeah, it does seem
I,
to
I've
work
sent
for that.
I've certainly done that within the mock-up of the exam interface, and I've never had a student afterwards I've never heard of a student feeding back afterwards that they weren't able to do that in the exam. If you find that the keyboard shortcut Control and F doesn't work, there is an icon. There's the little magnifying glass icon. Use that instead. But you can definitely search. Just remember that you're searching with whatever document you're viewing. So it doesn't have a feature that allows you to search all of the sources at once. You have to go into each source individually and search
Yes, that's a
again.
good point. Lauren's asked, do we need to distinguish between the sources that are not relevant and the sources which are relevant, or is it enough to correctly identify and apply the relevant sources? And I've replied that it is enough to
Yeah.
correctly identify the relevant sources.
Yeah. Don't waste your time writing in your report, this is not relevant, this is not relevant.
And
Just deal with
then
what is.
I've got a couple more questions. So, would you say it's best to focus on one issue at a time when going through the sources? My worry is rereading the same sources again could take up time unnecessarily. What's your thoughts on that, Sophie?
I think it is better to focus on one issue at a time. That said, so you'll have seen when I was going through Holsbury's, the first extract from Holsbury's, so source 6, I think it was, I was just I wasn't reading it all. I was literally just jumping from one heading to another. I was skimming through it. And my sense as I did that was that it all related to the Articles of Association, so wasn't relevant to issue number 1. Of course, I'm making a mental note that I might well want to come back to that for issue 2, but I'm not going to waste my time trying to think about too many things at once. I need to be really laser focused. That, for me, that's the approach that would work better. If you are worried that you'll forget that you saw something useful, then of course you could always jot it down on your whiteboard, or you could copy and paste something into the report and just drop it and leave it there. But I would stick to one issue at a time, trying to find the answer to that. Personally, I don't know. What do you think, Helen?
I agree with that, but that's because I have to stay very structured and methodical because I don't find it easy to hold lots of different ideas in my head at the same
Yeah.
time. So and I do think the feedback I get from students is that is the easier approach. As I think it's so easy to get muddled,
Yes.
particularly under time pressure and a
Yeah.
bit of panic. I
Yeah.
think that methodical approach of one step at a time, one issue at a time is better.
Yeah, I think the hardest thing is having the confidence in research to say to yourself, like I did with source 6, I don't even need to read all of this.
Yeah.
It doesn't look relevant. Move on to the next one. Hope, and then I found something really relevant in the next source. Had I not been able to find anything relevant, then yes, I might have to go back. But I haven't wasted lots of time reading irrelevant material. I'm skimming through before I decide what I'm going to spend my precious time reading more thoroughly.
Absolutely.
Getting an overview of what I've been given and what's in there.
And you can't rush it, can you? That's the frustrating thing. You can't rush through it. I mean, we all assimilate information at slightly different speeds, but generally speaking, you can't rush through it.
No.
I've had one message to me directly, which I think was just a mistake. It says, is it worth stating some of the facts in the introduction, or shall we leave it within each of the particular issues? And I would have thought it's finding that balance, putting some of the facts in the introduction and then drawing and weaving more in as you go through.
Yes, and it's going to depend on the question, isn't it, as to how you approach. I think you have to use your judgment and your common sense as to what's a good use of your time. Now, for this question, I think it made sense to summarize most of the stuff in the introduction and then be quite focused in the analysis. In a different question, you might find it flows more naturally to do it slightly differently. So there isn't a kind of hard and fast rule that you must do it one way or another, but for me, when I was having a go at this question, that seemed to be the logical way to deal with it, and that does mirror the way in which the SRA sample answer works as well.
Whereas in the probate one, our introduction was briefer, and then we did draw in more of the facts as we went through. So it does depend, doesn't it?
It does, yeah.
Okay.
I think the key is just that you show the examiner that you have appreciated what the key facts are, and you can do that anywhere. It doesn't have to be in an introduction at the beginning.
Thank you, Sophie. That was really clear. Hope I can be as methodical with my property drafting.
Okay, well, if anyone has any other questions, feel free to pop them in the chat. But I hope that was useful, and it was a bit of an experiment running it that way. So I hope you found it useful. But yeah, hand over to you now, Helen. All yours.
Yeah, thank you. I'm just going to close this bit down. I was just looking at the functionality myself, so I'll just close that down. Right, okay, let's bring up the slides. Hopefully you can now see the slides, and I'm dealing with the drafting exercise from week 14, and it's drafting a contract of sale in a residential property conveyancing matter. It's a freehold property. So just like Sophie did, because we're quite we're quite far through the course now, I know you're familiar with the basics of the drafting exercise and the assessment criteria. So I want to get straight into the question. Now, I have got a lot of slides to get through, so I'm going to go through them quite quickly, but I just wanted you to have the information that I'm going to speak about recorded somewhere. So I'm going to do the opposite of what Sophie did. I'm going to stick with slides for mine, and I'm going to let you all bring up the documents. I might jump into them occasionally. I have got some of them on the screen here. I might look at some of them. I may not. I've got a lot of it in slides. So if you want to look at the documents, week 14, and it's the property drafting exercise. So let's start off by looking at the question and what you have been asked to do. So in this scenario, you are working at the solicitors who are acting for the seller, or the sellers in this case. So our clients are the sellers of a property, and they are Neil and Samantha Brown, and they're selling 74 Hove Close in West Sussex. That's the property they are selling. Their solicitor, the solicitor at our firm, is Jo Goodwin. We've got her details there. And we are acting for the sellers. What else do we know about the sellers? Well, they're both still alive. We haven't been told that either of them have died, and they both are the owners of the property, and they occupy the property. And there are no other occupiers in this property. We're told that they're the only people that occupy the property. Now, they're selling the property, and you have been asked to put together a draft contract of sale. So that's our job in this drafting exercise. Before we start doing that, let's look at some more of the facts. The sale price that has been agreed with the buyer is £758,000. There's one buyer here, that's Maureen Cole. We've been given her address. We've also been given details of her solicitor. The parties have agreed a 5% deposit. So Maureen will be paying a 5% deposit as opposed to the standard 10% deposit, which I'll come back to shortly. With no instructions regarding completion date, that's quite normal. It's quite normal not to have instructions on the completion date. That's usually decided very shortly before exchange of contracts and then inserted into the contract at exchange of contracts. Again, we'll come back to that. So it's not surprising We might have a general idea when the clients would like to complete as soon as possible, or not for another 6 weeks or something like that, but we don't have a completion date. We have also got instructions that the sellers, our clients, have agreed to provide restrictive covenant indemnity insurance. So they've agreed to put in place some sort of insurance policy in relation to restrictive covenants. And it's in respect of the restrictive covenants that are missing. And that's been noted in the charges register. So that's a bit unusual, and we will need to come back and have a look at that in a moment. So you might want to make a note on your whiteboard of anything unusual that is sort of cropping up as we go through this. Might be worth doing that. So I've made a note that it's a 5% deposit, not the usual 10% deposit. And now I've made a note on my whiteboard that there's some sort of insurance that's needed. I'm going to have to make provision for restrictive covenant indemnity insurance. That's a bit out of the ordinary. What else do we know in our instructions? The other thing we've been told is that our firm, doesn't accept service by email, and that's quite common, but I'll make a note of it anyway. So I haven't noted down everything because most things are fairly standard in those instructions, but I have noted down on my whiteboard anything that I think is slightly out of the ordinary, and we'll come back to that. Okay, we've also been given in our documents, as well as having been given a blank copy of the contract and a copy of the standard conditions of sale, which I'll come back to, we've been given the all-important copy of the register. Now, we have got that. And the register, as you know, is broken down into 3 parts. Part A is the property register, sets out details of the property being sold. Part B is the proprietorship register, sets out details of the owners of the property, here the sellers. And Part C is the charges register, which sets out anything that burdens the property, any charges or encumbrances on the property, things like restrictive covenants, burdens of easements, and mortgages. Now, we do have a copy of the register. Let me just have a quick look at it now to get my head around what might be going on here with this restrictive covenant before we get into the drafting. So I've gone into the register. Well, there's the title number. I'll need that later when I'm drafting the contract. But let's just go down here and have a quick whiz through the register, see what's going on. Well, first of all, let's just check, is the correct register of this property? Yes, it's for 74 Hove Close. We've got an address for it. I'll need that later when I'm drafting it. Oh, we can see it comes with the benefit of an easement. I might include that in the contract later. That's fine. Let's go down and see what's going on in the ownership or the proprietorship register. Yep, the owners are Neil Brown and Samantha Brown. That's good because that's who we've been instructed by. There is a restriction here relating to a mortgage. So in a minute, when I get to the charges register, I'm going to expect to see a mortgage, and I'm also expecting to see something to do with restrictive covenants. And it also tells me how much they bought the property for, which is interesting, but it's not important for the contract. So let's get down to the charges register and try and get our heads around what's going on with these restrictive covenants. Now, we have the first entry number 1 in the charges register says, the property is subject to anything contained in the charges register. So let's see what is contained. A conveyance dated 1st of June 1967 contains covenants. What are those covenants? We know what they are because they're set out in the schedule. That's fine. We can report on that to our clients. They can decide whether to proceed with the purchase. And if they do proceed with the purchase, they'll know they're bound by those covenants. So they'll know what they don't have to do in order to not breach them. But let's have a look at entry number 2. A conveyance of the land in this title, dated 13th of February 1927, contains restrictive covenants. But the original conveyance and a certified copy has not been examined. It wasn't produced on first registration. So in other words, there is reference, presumably and probably in this conveyance, to one from 1927, which also contains restrictive covenants, but nobody's seen a copy of it. So this property is being sold subject to some restrictive covenants, some of which are unknown, and that's going to be very problematic for the buyer, isn't it? Because a buyer might buy the property, and under the rules of restrictive covenants passing with the land, if they are registered, then they're going to take subject to those restrictive covenants, but they won't know what they can't do in order to not breach the restrictive covenant. So So that's a problem. How do we get around this problem to ensure that this transaction can go ahead? The sellers here have offered, probably at the request of the seller, they've offered to take out a restrictive covenant indemnity insurance policy. And that's what we've got to draft into the contract. They have said, look, we will take out a policy in your name, buyers, so that if in the future you do something which breaches that restrictive covenant, and if you get sued for it by the person who has the benefit of it, which is probably a neighbour, and if you get sued, at least there'll be insurance that pays out. And as long as the sellers and they are prepared to do that and the buyer is happy for that solution, this will go ahead. And it's quite common to do that. Right, so we've got our head around what's going on with these restrictive covenants, and we've had a quick look through the register as well. So let's move on to the drafting of the contract bit. Now, in conveyancing, the seller's solicitor prepares the first draft. You've been asked to do that. And the purpose of the contract is to define the seller and the buyer, and importantly, to define the land that's being sold. Pretty easy when it comes to registered title. It also sets out the terms and conditions that have been agreed between the parties, things like the purchase price and whether any contents have been included and whether any fixtures are being removed and whether things like restrictive covenant indemnity insurance policy is being taken out. So it's an opportunity to reflect all those agreements. And once it's been drafted by the seller's solicitor, it is sent to the buyer's solicitor for approval. So we're at the drafting stage. So let's look at the standard form of contract in a little bit more detail. And the standard form of contract, as you will have seen, is in three parts really sandwiched together, all forming the contract. So you've got your front page, which is going to be filled in. You've got the standard conditions of sales sandwiched between the front and back page, and then you've got special conditions at the back. And when you're drafting a contract, it's important that you deal with all of this comprehensively. So let's learn a little bit more about each of those sections. On the front page, you just fill in the front page, and I'm going to go through each of the sections in a moment. You just fill in the front page according to the transaction details. It's pretty straightforward filling in the front page. So you want to pick up as many marks or as much credit as possible by filling in the front page as accurately and as well as possible. The standard conditions of sale, you're not going to be physically touching those, but you might need to refer to some of them and have a look at some of them. They are contractual provisions, which are, it is seen to be by the Law Society as pretty common to all transactions. They're the sort of things we would all like to have in our transactions. So we've got these standard conditions of sale, and then we've got the special conditions, and the special conditions are on the back page. They incorporate the standard conditions, and they serve two purposes: to amend any of the standard conditions which are not appropriate to this transaction, and to deal with any matters which are not covered by the standard conditions of sale. So you might already be thinking there, aha, yeah, we're going to be amending the standard condition relating to the deposit, because I know it's 5%, not the standard 10%, and we're going to be adding in a standard condition in relation to the indemnity insurance. So you might have already jotted down on your whiteboard, these things might be covered in special conditions. In fact, there are lots of things that are often amended or dealt with in the special conditions. So some of the special conditions have already been pre-printed, and we need to have a look at those as well. Let's move on. So I'm going to be going through the front page. I'm going to be referring to the standard conditions of sale, and I'm going to be going through the special conditions separately. So on the front page deals with the seller, the buyer, the property, the title number, anything which burdens the property, that's specified encumbrances, the title guarantee, the completion date, the contract rate, the purchase price, deposit, contents, and balance. And the special conditions, as I mentioned, they incorporate the standard conditions. They have some more commentary on the title guarantee. They deal with fixtures and contents. They talk about vacant possession, the completion time, representations, and occupiers' consent. And there's a space for notices as well. And I might even add to that. So that's what's on the front page. That's the stuff that's already in the special conditions. And these are the standard conditions sandwiched between, which are incorporated. So let's get on with going through each bit. We'll do it at some pace because we want to get done in the next 10 minutes, really. Okay, let's look at the front page first of all. First of all, there's a box up here, top right-hand corner, says for conveyancer's use only. It is for the conveyancer's use only. You don't touch it. That bit is completed in pen at exchange of contracts. So leave that bit well alone. Moving on to the date, leave it blank. It's left blank until exchange of contracts. Just like a will is left, the date is left blank until it's executed. Leave it blank. The date is filled in at exchange of contract, and that's when it becomes legally binding, as you're aware of. The seller. The seller is the person who has legal title to the property, and all legal estate owners have to be named. Now here it's pretty straightforward because it's Neil Brown and Samantha Brown. They're both shown as the registered proprietors. We know they are both still alive. So they are the sellers. Include their full names, make sure you spell them correctly, and include their addresses, or their address, as in this case, both of that address. So it's pretty straightforward here, but it's not always straightforward. So I've made a note on this slide of things you could look out for in other exercises. What about if there are two registered proprietors, but one of them has died? If that were the case, then the legal title has passed automatically by survivorship. The legal title, remember, can only be held jointly as joint tenants. The legal title will pass automatically by survivorship to the surviving owner. So the surviving owner in that scenario would be named as the seller. Let's imagine that we had two registered proprietors. They had both died. The person who would be named as the seller there is the personal representative of the second one to die. Legal title would have passed from one to the other. The second one dies. Their PR now has legal title. There may well be some questions coming up in the chat about overreaching. If there are, I'll deal with them at the end. It's not relevant to the contract. The contract is about who is entitled to sell the property. Overreaching is dealt with later in the transfer. Let's imagine that you had a sole registered proprietor and they have died. Pretty straightforward. It's their personal representative, so include their name. If it's a partnership selling it, a partnership does not have legal personality, unlike a company, so each of the partners has to be named. If it's a mortgagee exercising their power of sale, then the mortgagee, the bank, has to be named. And if it's being sold by an attorney, that's somebody acting for the seller whilst they're still alive, either because it's a general power of attorney, or maybe it's one of these lasting powers of attorney that kicks in when somebody's lost capacity. But if they're acting as an attorney, the attorney is the seller. It's the person who has legal title. The most likely tricky thing to come up, I would have thought for you, is the registered proprietor having died, or one of two registered proprietors having died. Possibly both registered proprietors having died. So I would suggest those top three, the most likely scenarios to be out of the ordinary, but watch out for the other ones as well, which is why I put them on there. The buyer, fairly straightforward, full name of all buyers and their addresses. So here Maureen Cole and her address has been given. The property, pretty easy with registered property. Have a look at the register for a clear description. Delete whether it's freehold or leasehold. So here leasehold should have been deleted. I'll just delete that now whilst I'm doing it. So it's a freehold property. We know that from the register, and you can just include the address from the register. You don't, with registered property where you're selling the whole of the title, and you know you're selling the whole of the title because it's the title number that's being shown next in the next part, then you don't have to also say together with the rights that are noted in the property register, but it's good drafting practice to do so. I know that's dealt with in the exemplar, so you can read about it there. It is, though, extremely important to describe the property correctly. Take a moment to check that you have described it correctly. Otherwise, the buyer could have a remedy for misrepresentation. So just take an extra moment to check you've got that bit right. Don't throw away easy marks. Right, title number or root of title depends whether it's registered or unregistered. Here it's registered, so you cross out root of title and you make sure that you put in the correct title number. Again, don't get that wrong, and also include the land registry's guarantee. the land registry's class of title there as well. If it was unregistered, I've just given you an alternative here. So if it was unregistered, then you give details of the conveyance which constitutes the root of title, and you cross out title number, leave root of title in, and you describe the conveyance. And I've given you an example of how you might do that. I've just made up a conveyance there, and I've assumed that the property has been defined earlier in the contract. But here we're dealing with registered. Okay, specified encumbrances. The seller has a duty of disclosure to disclose something which burdens the land and may restrict the buyer using it in a certain way. So you get this information from the charges register. So you must include here details of covenants, or if there were a burden of any easements listed here, you would include them. You can, the law allows, I forget which statute it is, probably the Law of Property Miscellaneous Provisions Act, but it allows you to refer to them rather than copying them all out. In fact, it's not a good idea to copy them all out because it's too easy to make a mistake. So have a look at how it's been done in the exemplar, the restrictive covenants referred to in entries 1 and 2 of the charges register of title number, and it's given the title number there. That's absolutely fine. What about that mortgage? Well, of course, we're not going to include the mortgage in specified encumbrances because the buyer is not contracting to take the property subject to the mortgage. We're going to put in place steps to ensure that the mortgage is paid off on or before completion. So as soon as the purchase, the usual way is as soon as the purchase money is received, the seller's solicitor, who has previously undertaken to do so, sends it to the lender and pays off the mortgage. Title guarantee. This is a guarantee given by the seller in relation to their quality of ownership. Now, an owner-occupier, like our clients, would be expected to give full title guarantee, saying that they have the right to sell the property and it's free from all charges and encumbrances and other third-party rights other than those we've already disclosed in the contract, unless it wasn't reasonable for us to know about them. Limited title guarantee is given by personal representatives or trustees because they likely don't live in the property, so they would have less knowledge of the property. But here we've given full title guarantee. The completion date. This is written in, usually almost always written in on exchange, and it will override the standard condition 6.1.1. I've copied and pasted 6.1.1 here because it gets us into the, and this bit is annoying because that's just the yellow's in the wrong place there, but let me have a look if I can show you this. If you don't put a completion date in on exchange of contracts, then 6.1.1 will apply, and 20 working days after after exchange is when completion takes place. However, almost always a completion date will go in at exchange, which will override that standard condition. But gets us thinking about standard conditions now, and I want us to start doing more of that as we continue. The contract rate. Now, the contract rate is the rate of interest that's paid as compensation on the balance of the purchase price if completion is delayed, if it's late. Now, what we've done in the exemplar is we've just repeated what the standard conditions say. So if you look at standard condition 1.1e, it says the contract rate means the law society's interest rate from time to time in force, and we've just copied that into the contract. But sometimes people use a different approach. 3% above the base rate of one of the main lending banks from time to time in force is something that you might see. Anything above 4% would be considered unreasonable. So 3 or 4% above a base rate is standard practice, or just repeat the law society's interest rate from time to time in force. Either approach is fine. Now, purchase price. Easy here, £758,000. So that's easy. We just stick that in next to purchase price because there's nothing here for contents. However, if the total price included contents, then it's sensible to apportion the purchase price between the property price, the purchase price, and the contents, because no SDLT is payable on chattels. And if that were the case, you would apportion between them and work out the figures based on that. And I've given you a little example of how that could work if that were the case. So imagine that a purchase price of £365,000 had been agreed, but £15,000 of it was a genuine it was a genuine price of the contents, a genuine valuation of the contents, and a 10% deposit has been agreed in this example. In that case, you could put down 350 for the property, that being the purchase price of the property, £15,000 for the deposit, £15,000 for the contents. The deposit is calculated by reference to the purchase price, but the balance is the balance overall. So I've put that little example in there so you can go back and have a look at it should that come up in an exam for you. Now, the deposit under the standard conditions is 10%, but it can be varied by agreement, and if it is put in differently on the front page of the contract, that overrides the standard condition 2.2.1, which says 10%. So here we've put in the deposit as being the equivalent of a 5% deposit. This bit at the end of the front page you can leave well alone. Once the document has been agreed by the seller's and the buyer's solicitor, then it's signed by the seller, signed by the buyer, or on their behalf in preparation for exchange. But in a drafting exercise, you can leave that bit well alone. So we now get to the special conditions. Now, the first two special conditions are pretty straightforward. I might have already talked about them already. So the first one just incorporates the standard conditions into the contract to the extent that we haven't amended them. And the second one just refers to the seller giving full or limited title guarantee. And we've already dealt with that on the front page of the contract. The third to the seventh special conditions I want to have a look at, and then I want to add in a special condition about the restrictive covenant indemnity insurance. So let's go through each of them. Contents and fixtures. We've already talked about it a little bit. Now, as a general rule, fixtures form part of the property. So if any fixture is being taken away by the seller, it needs to be listed now in the special conditions or attached as a list. Similarly, contents or chattels don't form part of the property. So if any are being included, then not only will you have put a price down for them, probably or possibly, but they should be included, either listed within the special condition or attached as a list. It should be dealt with here in the special conditions. The fourth special condition that the Law Society who developed this form see everybody wanting to deal with is vacant possession. So the seller is either going to say that they sell with vacant possession, in which case you would delete the second alternative there, or they're going to say the property is sold subject to the following leases or tenancies. We're going to delete the second one because they are selling with vacant possession. Now note, if there's an occupier in the property, I don't mean a tenant, I mean a non-owning occupier, maybe an elderly aunt or an adult child. They're living in the property, but they're not on the register, then they are a dangerous occupier. We have to deal with them. Or rather, the buyer is going to need us to deal with them. So I'm going to come to that in a moment. Just stating that the property is sold with vacant possession is not enough to deal with non-owning occupiers. So let's come to them in a moment. Before we do, though, the fifth special condition that you need to have a look at is this one. It says, look, conditions 6.1.2 and 3 take effect as if the time specified were other than the 2 p.m. So in those standard conditions, it says completion time is 2 p.m. on the completion date. In other words, the buyer has to get to the seller the money. They have to send the money, the balance of the purchase price to the seller by 2 p.m. and the seller has to vacate the property by 2 p.m. Now, it is quite common, and I know it's been done in your exemplar, to change that to an earlier time, 12:30 or 1 o'clock, particularly where it's a chain transaction and money has to move up through. Now, I think that I don't think it's wrong to have included it in the exemplar or in your answer without instructions, but I would say generally, if you haven't been given instructions on that, don't change it. I think if they were asking you in the exam to change it, they'd tell you that the completion time is to be 12:30 p.m. or whatever it is. But I especially just wanted to mention that to you there. Clause 6 is about representations, and only written representations can be relied on, and that's just standard. For example, replies to inquiries. So let's come back to this point on occupiers. Why are non-owning occupiers dangerous? They are dangerous for two reasons. One, because they might just stay in the property and they've not contracted to leave the property. They could just refuse to leave, but they're very dangerous because if they have a beneficial interest in the property, maybe they've contributed to the purchase price, and they are living in the property by virtue of their occupation, it can upgrade a beneficial interest, which might not be binding otherwise if they haven't registered it. It can upgrade it to overriding status. So non-owning occupiers are dangerous. How do you find out about non-owning occupiers as a buyer? You ask the question, usually in the standard pre-contract inquiries. So you ask, is anybody living in the property that doesn't own it? And that will either reveal that nobody is, it might reveal a lease, which you deal with separately, or it might reveal that, oh yes, our adult son's living here. If that's the case, then the sellers need to include a clause within the contract, and there is a standard one in there, and it does two things. It says that the occupier will vacate on completion, and also that they will waive any rights or any possible interests. They waive any possible interests in the property, and the occupier signs it, and that deals with the occupier. They would need to take separate legal advice, incidentally, but that's how they are dealt with. And I think they only need to sign the seller's part of the contract before it's exchanged. Finally, let's not forget to get a really good mark here. We've done pretty well already by doing all of this, but we've got to now do a bit of free drafting, because we know down here there's this covenant, there's this conveyance that's missing. So we know there are some missing conveyances. There are some missing covenants. We don't know what they are. So this is a clause that's been put in. Prior to completion, the seller shall arrange a restrictive covenant indemnity policy for an insured sum of at least, well, what choice do you have other than to put in the purchase price of the house? We've not been told what the value should be. So I think that's probably the best to go for, £758,000. Because if they were sued for doing something to the property that reduced the value of the property, the most it can reduce it by £758,000, as that's what it's worth. In respect of the restrictive covenants in a conveyance dated blah, 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 this policy shall be in a form approved by the buyer, such approval not to be unreasonably withheld, and shall be handed over to the seller, by the seller to the buyer upon completion. Now, obviously, you wouldn't have been able to come up with that if you'd not done this before. So I don't think that would have been possible to draft something that good in free drafting in exam conditions, but you can demonstrate two things. You can demonstrate an understanding of the law and that you are dealing with the client's instructions by just saying something like, the seller has agreed to provide the buyer with restrictive covenant indemnity insurance policy in respect of the restrictive covenants mentioned in the conveyance, and then you could say the conveyance. So I don't think it has to be that precise wording, it certainly doesn't, but you can demonstrate good understanding and get a good mark by just reflecting your instructions and having a go at drafting it. To bring it to a conclusion, we're a few minutes over, but to bring it to a conclusion, we had some instructions, didn't we, about not accepting service by email. So I've or the exemplar has crossed out the email address there, because including an email address authorizes it. So conversely, crossing it out doesn't authorize it. If you have any time left, and you probably would in a drafting exercise, because drafting is the one assessment that candidates, students seem to find least time pressured, go back and check, and at the very least check the front page. Have you spelt the names correctly? Are the addresses spelt correctly? Is the title number correct? At the very least, check that. If you've got time, have you filled in all parts of the front page? Have you dealt with all the pre-printed special conditions? If you absolutely have time, think about, did I deal with anything else? And here, there was the restrictive covenant point, and that brings me to the end. I went through that extremely fast, so I don't know if there are any questions.
There were a couple in the chat, Helen. There was one that I answered. I'll just run through it and check that you agree with what I said. But so when you were talking about the situation where you might have, for example, a personal representative selling or an attorney selling, and Leah asked, would the contract need to say Mr. X acting as attorney for Mrs. Y? And I said yes. And you would usually use just precisely that language, wouldn't you? Just say what capacity they're acting in. Okay, excellent. The next one you answered in the presentation, so that's fine. Alicia asks, is it enough just to write the figure of a lower deposit? So in other words, you don't need to specifically say a lower deposit has been agreed. You just put the agreed amount.
Yes.
Yeah, great. And that's actually it for questions in the chat. I don't know whether anyone has any additional questions.
Can I ask a really quick one, if that's right?
Of course.
Hopefully quick.
Of course.
In the exemplar, it says you won't be penalised if you don't delete, or if you do delete, sorry, the occupier's consent paragraph. Why would you include it if it's not relevant?
Well, I don't know. I would delete it, but I suppose I would delete it.
Okay.
But you've not put it. I can't remember quite what it says. Whether it just leaves parts of it blank. I suppose by not completing it.
It's crossed through some of the other sections, but then it says you're told the sellers live on their own, therefore this condition doesn't require amendment.
Yeah, I mean, I personally would
If it's
delete
redundant, you'd delete it.
Yeah, I would. Yeah.
Okay, thank you.
Yeah.
And there's just another question popped into the chat as well. For overreaching, should we add a condition that a second trustee be appointed?
I know it's a great question, Leah, and I did say I would come back to it. We don't need to deal with it in the contract at all, but what will happen, as you've rightly pointed out, that when we get to the bit where the money is being handed over and the transfer, if you were overreaching, if that was necessary, it's not here, is it? Because you've got two trustees. But if there was only one person and a second trustee was needed, so let's say you had a situation where you had two registered proprietors, they held as beneficial tenants in common, and you knew that because of the restriction in the proprietorship register, and one of them had died, the survivor could contract to sell, but when it comes to the transfer, the survivor would have to appoint a co-trustee in the transfer to take receipt of the purchase money. So this would come up in the transfer.
Okay. And Alicia asks, is there a session on completing a transfer? I'm not sure that there's one directly on that.
No, I don't think there's one in these sessions. No,
I don't think there's a workshop that covers that, although I'm sure there's information in the materials as well. And then somebody else asks, any tips on drafting other property related documents, i.e. for leaseholds? Gosh, that's a wide one.
No, I think it's a fair question. I think it's a fair question. No, we can't. No tips in this session, because that's a huge question. But it is important, and I think one thing that I sometimes say to people is, as you're going through your revision and the revision book and the functioning legal knowledge, and you're revising, it's worth just pausing each time you revise something and thinking, could this come up in a drafting exercise? Is it realistic this could come up in a drafting exercise? And if it could, it's worth you, if you haven't dealt with it in the Barbary materials or in a workshop or in an exercise, and I don't know what other exercises are coming up, and I don't know what mocks are coming up, but if you haven't dealt with it and covered it, then it is worth you going away and researching it on your own and finding out, okay, let me have a look then at what a landlord's license to assign. If you come across that and you think, I'll just have a look at one of those, having a look at what it looks like, so that if it did come up, I think more likely ones that will come up, the ones you cover on the course, but if it did come up, it wouldn't have been the first time you'd have seen it. And I often say that about in wills and probate. Have a look at some of the documents that are referred to, even if you've not done an exercise on them. So maybe have a look at a probate application form, and maybe have a look at the inheritance tax form for claiming the transferable nil rate band, things that are mentioned in the functioning legal knowledge, but you might not have done an exercise on. And in that way, you're sort of, and I am a bit boring when I talk about adding things into your toolkit, but you're sort of adding bits into your toolkit, but not spending a disproportionately long amount of time. So it's not tips on those documents, it's tips on perhaps how to approach that issue.
Becky makes a good point in the chat as well, actually, and I think she's right. There are some videos in the additional content which cover drafting transfer of whole or part, and I think you're quite right there. There are also, of course, in the addition, so this is on the PSP, on the content page, under additional materials.
Yeah.
Under each practice area, there are example documents, and there are lots of short micro videos where a tutor will talk you through something, specific things that are relevant for SQE2 in that practice area. So that
and the
is a
property
really
ones
good
are very
place to
thorough.
look. They
are.
There's lots of them, and they're really comprehensive. So I think you probably will find what you need there. Actually,
good tip.
Yeah. Okay. Anything else, anybody? I'm conscious we've gone over time a little bit, but I think that was a really thorough and helpful session there from Helen. So thank you. Thank you, everybody, for coming along. And
make sure our slides go
yes,
up, won't we, Sophie?
we will, yeah.
Great.
The slides will go up. They'll probably appear sometime tomorrow, I would have thought, along with the recording of the session as well. Okay,
Great.
Thanks very much,
Thank
everybody.
you. Bye, everyone.
Bye.
Yes, it was quite difficult to get through. I'll just stop the recording now.